So welcome to this free session where myself and my colleague Peter Jorro are going to discuss issues arising from judicial reviews and Upper Tribunal statutory appeals, so the two arenas in immigration law where the Upper Tribunal does most of its work. And our rationale for doing this session is, of course, to promote the second edition of our book, the Immigration and Appeals Remedies Handbook. Pete's holding it up there. As the session proceeds, at times I'm going to screen share aspects of it with you, just so you can see how we explain things. We do have a voucher code available potentially, if you can put a finger on it by the end of the session. We'll have to see about that, which may get you a discount. But if even if we don't manage to produce that during the session, I'm sure we can send it round anyone who's participating in this session thereafter. Pleased that potentially so many people have signed up, almost 650. We had the 450 we had last time broke all records at Garden Court. So certainly in terms of sign-ups, we've broken records again. And I hope the session's interesting to you. So without further ado, I'm going to hand over to Pete to start off with some information about Upper Tribunal statutory appeals. Over to you, Pete.
Yes, thank you very much, Mark. So what I'm going to be talking about is a couple of topics coming from Chapter 4 of our book. Chapter 4 of our book on appeals to from the FTT to the UT and beyond. Now, the UT chapter, as I say, starts off with discussing the general principles in the introduction. And basically what I'm talking about today is the statutory appeal framework, whereby a person or a party unhappy with the decision of the first tier tribunal can apply via a dual system with some extra bits for permission to appeal to the upper tribunal on a point of law. It's all based on the Tribunals Court and Enforcement Act. And therefore, one needs permission to appeal on an error of law. And in chapter 4.5, we look at the challengeable decisions and also what are considered to be excluded decisions, which cannot be subject to appeals in the statutory scheme, but instead can be subject to judicial reviews, which Mark is going to be talking about with reference to chapter 6 of the book. So the first issue is that you have the question has to be an error of law, and it has to be a material error of law. 4.9 in the book, we talk about materiality. And there we have some references that in terms of permission should only be refused on the basis the error was immaterial if it is plain case that the error could make no difference to the outcome. And there's some very helpful references throughout these sections to the UT's own guidance, the Presidential Guidance 2019 number 1, which is referenced in various footnotes throughout the bits that I'm talking about, and which can obviously be found by anyone looking on the internet by putting in the Presidential Guidance. And it's all there in those chapters. Now, the first point is that applications for permission to appeal have to be made originally to the first tier tribunal. And chapter 4 deals with that, starting from 4.13, in terms of what must be done in making an application to the first tier tribunal. And there's various technical issues that can be read there. But an important point is this, is that one of the points that's quite interesting with the new business of a lot of electronic matters, in the case of SYR, permission to appeal, is referenced at 421, making the point that when a first tier judge is dealing with an application for permission to appeal, it's vitally important that he or she has full access to all of the material that was before the first tier, nowadays frequently in electronic form, PDFs, emails, and so forth, because otherwise they won't know what's going on in terms of making their decisions. Now, what the book does is it summarizes the various powers and duties of the first tier tribunal and has a very helpful summary at paragraph 4.31 on those. It's a feature of the system that when the first tier tribunal makes a decision on grounds of appeal, it can grant or refuse permission to appeal, or it can grant limited permission to appeal on some grounds only. And in the case of SAPI, referencing this point, 4.28, it makes the point that it's vitally important that when the first tribunal does that, it says so in the reasons. It says so in the decision, not just in the reasons, that permission to appeal is being granted on grounds 1 and 3, but refused on ground 2. Now that has consequences, because a person who's been refused permission to appeal on one of the grounds, but wants to pursue that to the upper tribunal, the party must make a separate new application under Rule 21 of the Upper Tribunal rules for permission to appeal to the Upper Tribunal. Once the matter is before the Upper Tribunal, various interesting issues arise, which we're going to talk about now in terms of the bullet points referencing this, revisiting permission grants and refusals, including CART JRs. Now, it's always been, for a very long time, a provision that says that when a tribunal decision maker is deciding on whether or not to grant permission, they must decide whether the grounds make out the arguable error of law, or alternatively, if there are any Robinson obvious points. Robinson is a case involving the Refugee Asylum Convention, and made the point back in the Court of Appeal that where there's an obvious point that the first tier tribunal has erred on, the tribunal judge can grant permission of his or her own motion without it necessarily being in the ground. But it's a very limited jurisdiction on Robinson, and we deal with that at 413 to 431 in the book. Interestingly, as I've made the point, is that the first tier tribunal will decide whether or not to grant permission on each ground. The President's guidance makes it very clear that it's not generally a good idea to limit the grounds of appeal. It's generally more helpful, if you're going to grant permission on one ground, to grant permission on all the grounds, unless there's a particular reason for not doing so, and that it's reasonable for the first tier judge to maybe make clear which grounds he or she thinks have the strongest basis for the grant, rather than to limit the grant. But what we're looking at now is a situation where a matter comes before the Upper Tribunal. Now, there's a couple of recent cases which I'm going to talk about, and also a case that's referenced in the book called Jan, Upper Tribunal Set-Aside Powers, and it's referenced in the book at paragraph 4.448. Now, the point to this is that the system worked on the basis is that once the Upper Tribunal has made a decision on whether or not to grant permission to appeal, that's a final decision on the matter, which can't in itself be appealed further to the Court of Appeal. Now, in the case of Jan, it's a case from 2016, 2016, look at 336. What had happened there is that the appeal had been dismissed. The appellant applied for permission to appeal to the first tier and was refused, and then renewed the application for permission to the Upper Tribunal, which was also refused in September 2015. And what the appellants then did is that they sought to challenge that decision by way of seeking to use Rule 43 of the Tribunal Procedure Rules. They said that this was the basis upon which a further challenge could be made for a review of procedural error. And in the case of Jan, the tribunal were very clear. They set out a whole series of bases on which Upper Tribunal decisions can be reviewed, and rejected out of hand the suggestion that a refusal of permission to appeal by the Upper Tribunal, other than on the basis of a slip or something, could be reviewed by route of the Upper Tribunal rules. The only remedy for it would be by way of what's called a CART judicial review. And we'll come to that, and we'll talk about judicial reviews in a bit. But what we've had quite recently is a series of situations in which the Upper Tribunal has dealt with cases regarding CART JRs. And they're both from April this year, and I want to just reference them. The first of those is a case called Osefiso, PTA Decision Effect CART JR, and it's 2021, Ukut 116. Now, in that case, what had happened here is that the appellants' appeals had been dismissed by the judge on the first tier, and they had applied for permission to appeal on rather weak grounds to the first tier and been refused, and then had made another application for permission to appeal to the upper tier, which had also been refused. What they then did is that they made a CART judicial review application. But the CART judicial review application they made had nothing whatsoever to do with the grounds upon which they had been refused by the Upper Tribunal. And that's considered a complete no-no in the case of MA CART JR, which is referenced at 4.69 in the book. This case I'm talking about now is a more recent one. And what they then did is that they put in an amended application for permission to appeal to the UT after it had been refused, in order to say that this was the basis upon which they should be able to be given permission to appeal on the CART JR. A rather sneaky approach, which was accepted to be done in perfectly good faith. But this was completely rejected by the Upper Tribunal, saying that you can't do that. Once the Upper Tribunal has refused permission, there's no basis upon which you can come back to the Upper Tribunal other than under the slip rules. And that the CART JR had to address the grounds upon which permission to appeal had been refused by the Upper Tribunal is not a third go. There's one of the differences. When you apply for permission to appeal to the first tier and refuse, your application to the Upper Tribunal is not limited to the grounds upon which you appear to the first tier, but can actually proceed on the basis of entirely new grounds, preferably improved grounds. So in this case, the Upper Tribunal said this wasn't a possible thing to do. You can't try and amend it and then use a CART JR. In the event in the case, they agreed that the point upon which the CART JR succeeded was a Robinson obvious one, and so the appellant was successful. But they did make it very clear at the end of their judgment. Having said this, we have to say that those acting appellants took the steps they did in entirely good faith, i.e. making a renewed application, a third application in effect, the Upper Tribunal, in order to try and justify the CART JR Tribunal. We do, however, expect that in the light of our decision in the present case, no one should repeat those steps in future. So there's a point there. So in other words, the system is very clear. One application to the first tier, which can be granted or refused or granted on limited grounds. If it's on limited grounds and the party wants to proceed to the Upper Tribunal on those refused grounds, then they need to make a new application for permission to appeal to the Upper Tribunal on those grounds. And then the matter comes before the Upper Tribunal on the basis of the grounds that it's accepted or not. If it's refused by the Upper Tribunal completely, then CART JR is the only remedy, but the CART JR is limited to challenging the reasons given by the Upper Tribunal for refusing permission to appeal on the grounds that went before it. And that leads into the next new case, 28th of April this year, called EH PTA Limited Grounds CART JR Bangladesh 2021 Ukut 117. These are obviously all on Bailey, seen from this. Now, in this case, a different scenario happened in which the Upper Tribunal had actually granted permission to appeal on limited grounds to itself, whereupon the appellants went and launched a CART judicial review seeking permission to appeal on the grounds which had been refused. Now, again, what the tribunal in this case said was that that was impermissible because a CART judicial review challenging that can only be on the basis of a refusal of permission by the Upper Tribunal. So in other words, where the Upper Tribunal had limited the grounds upon which it granted permission to appeal, a CART JR was not a permissible remedy. However, because of the wording of the procedure rules relating to what stands as a grant of permission to appeal in Rule 22, the fact is that the application for permission to appeal stands as the notice of appeal. And though the Upper Tribunal under Rule 22 can seek to limit the appeal by directions, those directions in turn can be varied under Rule 5. And so where the Upper Tribunal makes a decision to limit the grounds upon which permission is granted, instead of going to the High Court to challenge that, the proper remedy is to seek to vary the order given by the Upper Tribunal in terms of limiting any grounds, with the result that all grounds then become arguable before the Upper Tribunal subject to directions. Now, that leads back into the issue of CART JRs and JRs generally. And so Mark's now going to talk about some issues relating to JRs in chapter 6 of the book.
Thanks very much. Yeah, so in my first brief talk, just by the way, in terms of the structure we're going to follow, we aim to do about an hour of discussion between ourselves on these current themes in statutory appeals and JRs, and then we'll have half an hour of questions. That's in terms of how much of us you have to put up with. Okay, you'll notice that the version of the book that I'm screen sharing, when I managed to do that, is in fact my own electronic version, and you too can get this, and you'll see that it's marked and copyrighted, as it were, with your own name at the bottom of it, and it gives the purchase date, so it gives some integrity to the system. A few thoughts on judicial review, just to start off with then. Obviously, the Upper Tribunal jurisdiction's developed quite a lot, since its inception. Now, its inception, can you believe, was very nearly 10 years ago, October 2011, is when the first cohort of JRs, in those days just fresh claim cases, moved from the heady world of the High Court into the world of the Upper Tribunal at Field House. And then November 2013, we saw the next wave of cases come over, which was in fact most cases in the immigration jurisdiction. Not everything, of course. Essentially, what the Immigration Tribunal does is cases about the Immigration Acts, decision under the Immigration Acts, more than anything else. Now, the High Court, on the other hand, deals with immigration detention, with trafficking cases, with a whole series of other kinds of cases. It deals with sponsor license JRs. Beyond detention, it deals with various kinds of civil claim relating to immigration. So, you know, it's retained quite a lot of work, probably more than it would ideally really like. Here we are. Eventually, after a bit of scrolling now, I managed to locate the right bit of the book. There's a list. Yeah, there's a list. And there's the Upper Tribunal's jurisdiction, decisions made under the Immigration Acts, instruments under them, and decisions made outside the rules, and decisions of the FTT where there is no appeal to the UT. So those restrictions are interesting. Another feature of them, of course, is that whilst only the High Court can deal with challenges to vires of statutes or rules, no one says anything there about Home Office policies. And in fact, that means that the Upper Tribunal has jurisdiction over Home Office policies, and it exercised it from time to time. In Delegates Legato, I think the case was called. It dealt with the fee waiver policy, and it's also dealt with cases on the restricted leave policy. The fee waiver policy didn't survive challenge. The restricted leave policy, of course, did. So it's interesting, this distinction between the two jurisdictions, and one always has to remember, quite, you know, when signing off one's JR, make sure you're lodging in the right forum. Otherwise, they do say there can be cost implications, though I've never really seen any. But you could be hit with real delay if you lodge in the wrong place. There is a tendency, of course, for people to lodge near the time limit, which means you can't just take it out and start again without risking being out of time. So you have to get it transferred, and there's a certain amount of fussing around there. Another feature of all that, of course, is that it's applicant and respondent in the Upper Tribunal, not claimant and defendant. The law of the Upper Tribunal is found in a series of documents, like the practice statement and the practice directions. Not that easy to find, it has to be said, on the Upper Tribunal website, but they are lurking there somewhere. Another feature of the modern Upper Tribunal system is that OISC firms can now get a judicial review case management license, JRCM procedure, and they can, once they've obtained that license, they can litigate with public access qualified barristers with a litigation license. And there's even, you know, in the endless jurisprudence of the Upper Tribunal, we now see a bit of guidance about that and how important it is to make sure that everyone involved is properly registered under the regulatory system, with the barrister being actually being the person who conducts the litigation. So, you know, the immigration world brings its own distinct features. Checklists. One feature of the book I wanted to mention before I leave my brief introduction to JR. The publishers encourage us to put checklists in this edition, and checklists you get. So, for example, for when filing a JR claim, we give you a full list of the relevant processes and procedures and all the issues to consider, right through to the obvious ones, such as dealing with biographical data of the people involved, to explaining how to fill out the form, to understanding what each of the different remedies might involve, to the relevance of a statement of truth by a solicitor or claimant where relevant, particularly where facts and factual history is being asserted, which isn't otherwise found in the paperwork. So, of course, you could have a fresh claim JR, for example, or CART JR, I suppose, where, of course, the paperwork is completely self-explanatory and there's nothing else relevant. On the other hand, JRs of moving targets, JRs of urgent removal and so forth, there may be a lot more that can be usefully explained behind the scenes. Okay, just one topic I'll just have a quick look at, delay and so forth in JR proceedings. And forgive me, I had a slight problem with my upping and downing then. Delay in JR proceedings, of course, as we all know, you have to bring your claim within 3 months, but even within that, you have to bring your claim as soon as possible. The law on public funds and so forth has moved from time to time. Public funds, is most commonly relied on, lack of public funds, most commonly relied on excuse or explanation for not bringing a timely JR. And what the case law has told us over time is that that's not necessarily in its own right going to be a perfect excuse. And so we see quite a lot of cases. Actually, we might not see the case end. I'm going to tell you about them. Starting up in CASA back in 2003, right up more recently to HISAG in the Court of Appeal just 3 or 4 years ago. This series of cases discusses in some detail the relevant law on delay. Essentially, that even obtaining public funding is not necessarily a legitimate excuse for a delay, and therefore it's very important to make sure that one gets the funding as soon as possible, and really I suppose that one lodges doing minimal work at least in order to secure the client's position before better to lodge and take a slightly worrying possible hit on a bit of your casework being paid than it is to wait and go out of time. Another topic that I wanted to talk about before handing back to Pete is alternative remedy. So alternative remedy is an area that at one time had a very clear delineation in immigration law, the idea being that you always had to bring your remedy in the appropriate forum. JR was only possible where there was no alternative. There are all kinds of variations on that, of course. We see case law like Dong that tells us that maladministration claims can be pursued via complaints procedure rather than bringing a JR first. JR should even be stayed once that is realised, however far they've got, even days before the full substantive hearing. Rights of appeal should usually be pursued unless special circumstances, to which I will revert. The first-tier tribunal should determine its own jurisdiction. So really, if you ever find yourself reviewing or writing JR grounds where the issue is we should have been given a right of appeal, query, are you doing the right thing? Because really, probably what you should be doing is lodging your appeal, your arguable appeal in the FTT. Very hard for you to be criticised thereafter. I suppose belt and braces would suggest you could always lodge a JR at the same time and just ask for the JR to be stayed because of the FTT proceedings. But I don't think you could be criticised for saving the JR until later. A series of cases like Lim a few years ago, LIM, said the LJ in Lim told us that where you had an out-of-country right of appeal, that was an effective remedy in most cases. Parliament had decided people should have out-of-country appeals, and it would distort parliamentary's wishes to go behind that statutory policy. Sedley and Lim said that if there's a fundamental issue in play, such as were you British or not, then you should be allowed an in-country JR. However, recent developments, Arsan and Balajagari and all that, of course, have blown open the field of alternative remedy in JR, as well as giving us more notions of what is fair and what due process involves in immigration JRs. What we learn then is that the remedy system is rather complex, and at times, as we see in all the TOIC cases, the Home Office is going to be expected to work with claimants in order to give them a genuine and effective right of appeal where appropriate. And you see a whole line of cases after Arsan, which basically explains how in practice that is going to be worked out. Partly turning on the fundamental issue, of course, that the courts now think that an allegation of dishonesty, not a genuineness dispute necessarily under the points-based system, but a pure allegation of dishonesty always needs to be determined via an oral hearing, which will require either the generation of a right of appeal or that the upper tribunal entertains oral evidence in the JR. The other great development on alternative remedy, of course, was the Chiari and Bindloss line of thinking. And in Chiari and Bindloss, we saw that the government policy, very strict policy, was introduced with a view to ensuring that there were out-of-country appeals in most cases. Great victory achieved in Chiari and Bindloss in terms of establishing that, generally speaking, at that time, out-of-country appeals were not really effectual. Remote hearing is actually what Pete and I are doing in the next session, but I just touch on the issue here because it's so relevant to a core aspect of the fluid world of judicial review. Legislative policy then obviously is for deportees, and of course, let's not forget, under the legislation, nearly everyone else as well with Article 8 cases has never been brought into effect should have an out-of-country appeal. It's been explained in more recently that the video, not surprisingly, in the remote hearing era, the technology has improved, and now one of the reasons for arguing that an out-of-country appeal is ineffectual will have to be rather more sophisticated, one imagines, involving accessibility of evidence more than the technology itself. Most recently, we saw Mostyn a few weeks ago in language that reminds us of the heyday of Sir Andrew Collins. He says the court should not be straining to find obscure loopholes, the exploitation of which would render this process nugatory. Okay, so there's a few points on JR. I'll hand back to Pete now to tell us more about current issues.
Yeah, thank you very much, Mark. Now, just to answer one of the questions that's arisen, it's a very good question in the Q&A part. The system works as follows, is that what I was explaining before is that if the first tier tribunal grant permission on only limited grounds, then the remedy for that is to make an application to the upper tribunal for permission to appeal on those grounds. That's very clear, SAFI and so forth, and it's explained in the section on the FTT. If the upper tribunal grant permission, but only on limited grounds, then what the recent cases make clear is that means that you cannot then lodge a carte judicial review seeking permission on the grounds on which you were refused, but rather the point is made is that the Rule 22 of the Upper Tribunal's rules make clear that subject to any direction by the Upper Tribunal, the application for permission to appeal stands as the notice of appeal, and the Upper Tribunal must send to each respondent a copy of the application. In terms, therefore, of the notice of appeal, it's all the grounds that were put in the application for permission to appeal to the Upper Tribunal. If an Upper Tribunal judge has decided that only some of the grounds have arguable merit, arguability being the test, then the Upper Tribunal under Rule 22(1) must then, 22(2)A, must send written notices and a direction of limitations on the grounds. But the point being made by the tribunal in this very recent case of EH, the one on 28th of April this year, was that if nonetheless the appellant wants to argue all the grounds, the way to deal with that is to make an application to vary the direction, which is something that can be done under Rule 5. So there's the answer to that particular question. In other words, if you want to argue all the grounds and you apparently have a limitation set by the Upper Tribunal, you simply apply to the Upper Tribunal seeking to vary the grounds. Now, whether they do so or not is another matter, but obviously that's then something that can be argued as a substantive error of law hearing. Before we get to errors of law, there's another issue that has some recent decisions and case law on it, which is this business of the Rule 24 response. So paragraph 4.43 of our book looks at responses to the notice of appeal and cross appeal. So I just want to briefly talk about this before we get into what the errors of law are. So 4.43. Now, 2 points on this is that, one, in a very recent case called Devani in the Court of Appeal, Lord Justice Underhill, and with agreement of the other judges, has said that where a respondent wants to resurrect an argument that failed in the first tier tribunal, the respondent must put in a Rule 24 response. It's not optional. And in fact, at the very moment, ILPA is looking into proposals from the Tribunal Procedure Rules Committee about whether they want to change Rule 24 to either confirm the Court of Appeal judgment in Devani for all such cases, or to reverse it by way of the rule. The other point that's always worth bearing in mind, that's thunder and lightning coming from where I'm sitting. The other point that's worth bearing in mind is that there are certain cases where, the obvious one, for example, where someone is appealing on asylum protection grounds and also on human rights grounds. The last session we did, this is the FTT, we looked at all the new system, this 2014 system limiting grounds. And it's important to bear in mind that a party might win on the asylum protection ground, but lose on the human rights grounds. And the party, of course, might be the Secretary of State just as much as the immigrant. It's very clear from the system that a party who actually loses on a substantive ground can't use the Rule 24 approach to revive that ground. That has to be done by way of an application for permission to appeal. Then obviously you can have cross appeals. It could be, for example, that the appellant, the immigrant, won on human rights, Article 8, but lost on asylum. Now, if the immigrant wants to challenge the asylum dismissal, the immigrant must make an application for permission to appeal. If, on the other hand, the Secretary of State doesn't like the Article 8 appeal being allowed, then the Secretary of State must make an application for permission to appeal. That's very clear from the case law that's referenced in paragraph 443, EG and NG, and the case of Smith. The point being made in the case of Smith was that from an appellant's point of view, there's only reason to do that if you've lost on the stronger ground. The Rule 24, though, is an issue that relates to relevant arguments within the ground of appeal. So, for example, where somebody has won on a particular issue, but the other side says that the judge actually got it wrong, not just on, got it wrong on an alternative issue within that, internal flight versus protection, for example. And that's where the Rule 24 comes in. And according to Devani, is that a losing side, the respondent, the winning side in the first tier tribunal, the respondent to the upper tribunal appeal, who wants to resurrect an argument that the respondent lost in the first tier, must make a Rule 24 response. That's the current state of the law. Now, just looking at errors of law, because as we've already ascertained, is that the permission to appeal in statutory appeals only applies to material errors of law. And so we start looking at those in the book at part 6 of chapter 4 from paragraph 4.105. And unsurprisingly, we set out there the classic setting out of errors of law from the case of R. Iran back in 2005. And so the standard errors of law: perverse or irrational findings on matters that were material to the outcome, failure to give adequate reasons, failure to take account of irrelevant matters or facts or conflicts of opinion, giving weight to the material matters, material misdirection of law on any material matter, or committing or permitting procedural or other irregularity capable of making material difference, making a mistake as to material fact. Every single reference being material. Now, we've looked at materiality very briefly. The test, though, is that there has to be, it is in a sense for the respondent side to show that had the error of law not been made, it's pretty well inevitable the decision would have been the same. But nonetheless, it has to be a material error of law. And we set out in the book the judges making it very clear that people who make grounds of appeal to these tribunals have to be very careful in terms of backing up what they say is an error of law rather than simply asserting it. A very recent case called Taj, which we reference at footnote 5 in paragraph 4106, is rather helpful on the business of what is irrational. Now, we have lots of arguments about irrationality in these cases, and certainly some of the cases that the Home Office will defend, they will say that irrationality is a sort of test that's extremely high indeed. In the case of Taj, Lord Justice Green made the following points. Where it is said only that the decision is irrational, in the sense that no reasonable decision maker could have come to that conclusion, the court will work out the appropriate margin of judgment or discretion for the court of the decision maker. And that's an important point always to bear in mind in these rationality challenges. There are many authorities which in broad terms mark out the cases where a broad margin is afforded to the decision maker. These include where the decision is essentially a political one or imbued with high policy content, or the decision based on complex and uncertain or technical or scientific evidence, in which respect there may be no single unequivocal answer, or where the decision is taken on a precautionary basis, such as health or environmental risk. Where, however, the decision has none of these hallmarks and is more mechanical or micro, then the court will accord a far smaller margin of judgment. And obviously that then links in with the need for anxious scrutiny in asylum cases. So it's always worth bearing in mind those tests regarding rationality. In the book, moving on, we deal with classic issues to do with reasoning, and paragraph 4.107, the issue of materiality. An error must be material in order to render the decision unlawful. As to doubt whether an error is material, one must resolve in favour of the individual complaining of the error, the point I was making. Once some findings have been identified as unlawful, the decision may be only upheld where the tribunal could tolerably confident the tribunal's decision would be the same but for the error. That deals with those. Paragraph 4.108, we look at bias, case management, fairness, and decisions made in ignorance of decisive facts, and some of the tests regarding that. Certainly worth looking at. And at paragraph 4.118, we set out the presidential guidance on drafting grounds of appeal, which is always worth looking at in terms of the professional behaviour, setting out those compelling applications and how that should all be done. I won't read that through, but if Mark can maybe show paragraph 4.118. So the point being there, the grounds don't prove themselves. They have to be based, if you're making particular issues about procedure or by way of unfairness, then you need witness statements, references to the presidential note and so forth. The ground should be as succinct as possible. And the presidential guidance also addresses the response to grounds by the judge determining appeals. And there's always this very strong admonishment not to sink into setting out some simply sort of normal repartee. And everything should be dealt with on the facts of the case itself. But that's particularly worth looking at, that paragraph there. Now, in terms of errors of law, because of the public law nature of it, the errors of law for statutory appeals are very similar to the errors of law relating to judicial review issues. And so I shall hand back to Mark, because Mark wants to talk to you, I think, something about avoiding Hamid hearings, Mark.
Yep, indeed. So one of my potential topics is the Hamid hearing, and obviously this is something which we do very much want to avoid in practice. There are two areas where representatives in JRs tend to get the most criticism, and the Home Office tend to get it in relation to duty of candour, because the Home Office style in terms of speed of thinking often leaves them susceptible to criticism for not producing and researching and finding stuff on file quick enough. And if anyone ever thinks that, representatives, claimant representatives get unfair treatment from the Upper Tribunal, you should read what they say about the Home Office in a whole series of cases about the duty of candour. But the Hamid hearing, let's just have a quick look at the procedure there. So these have tended to develop over time in relation to application for interim relief. And I think that's probably because the Home Office, or the court, especially the administrative court, gets extremely upset about interim relief applications unless they are truly fully justified, because these are pieces of work which change the contour of a judge's day, and the judges are not, in fact, probably on average sitting there doing nothing normally. They're quite busy already. And suddenly when things are thrust into their hand, demanding their attention and requiring reordering and staying up late and cancelling of other arrangements, there's obviously scope. There is scope for judicial anger if it transpires that the urgency wasn't all that it was thought to be, or that the case hadn't been properly prepared. So we do tend to see this in relation to interim relief cases. So under the Hamid hearing process, the Upper Tribunal, it tends to be up. I think the idea is that the Upper Tribunal would normally do these rather than the admin court. The solicitors and senior partners are required to attend the hearing. Judges may refuse to consider the application for interim relief. A referral to the appropriate regulatory body may be made. And that they intimate the proposal to have a Hamid hearing by a show cause letter normally. So the idea is that in receipt of the show cause letter, you'll have an opportunity to explain your case. And I think probably if one gets one of these letters, it's probably the time to think carefully about one's position and to, do whatever one normally does. You may be counsel yourself, or you may be an in-house advocate with higher rights. But whatever, bear in mind the possible advantage of bringing in someone independent of the censure that may be shortly to fall. Also, bear in mind the need to explain very carefully all the casework steps that have been done. And remember that the courts in these cases are really interested in a management exercise. That's what they're looking at. They want to know, they may want to tell you off for sins of the past, but what they're most concerned with is monitoring systems and making sure that what has happened is an aberration. and won't happen again. So in a sense, the Hamid hearing or the show cause letter is an opportunity for a management consultancy exercise in strong supervision processes. And I suspect that's perhaps the best way of trying to fend off those processes in practice. And also do bear in mind, I mean, but obviously with urgent removals, it's obvious what the urgency is occasioned by, because if your client is removed from the UK, then that may, in practical terms, end any serious challenge they can bring to the decision they'd like to challenge. But anything else where they're not actually facing removal, do bear in mind the need for a bit more rather than less time for all involved. Okay, so Hamid hearings, endlessly topical. Let's have a quick look at something else which is topical, and that's damages. So damages are likely to crop up in a series of different ways in our casework. We're very familiar with the procedure on damages for unlawful detention cases. Basic idea obviously being that the JR can challenge present detention, but once present detention is historic and the person is being released from detention, then a civil claim is likely to be the best way forward. So, the territory of those JRs is relatively straightforward, I'd suggest. Found it eventually. But damages, in fact, are increasingly being appreciated as available more generally in immigration proceedings. So, and there's an ebb and flow in their availability. As we retreat from the European Union, some kinds of damages may become less feasible. But as the common law develops, other kinds of damages may move on something. ID in Home Office, one of the great immigration cases. There's on the face of it nothing in the slightest bit peculiar about an individual bringing a private law claim for damages against an executive official who has unlawfully infringed his private rights. And so there's all kinds of torts and so forth that have been recognised over the years as possibly giving rise to damages. Assault and battery, as well as imprisonment, malicious prosecution, the tort of conversion, e.g. where the government hangs onto your passport for impermissibly long time. Misfeasance in public office. And for many years now, there's been a problem in immigration casework because it's very difficult to get damages against the Home Office outside of EU law, detention or human rights. And that's because it's been largely understood that the only available action would be misfeasance in public office. And misfeasance in public office requires you to show not just negligence, but outright intentional vindictiveness, targeted malice by a public officer, conduct specifically intended to injure a person or persons, or where a public officer knows that they have no power to do something and that it will probably injure the plaintiff. So, pretty tough going, these damages cases. However, recently a flutter of activity in the Supreme Court has led to a kind of restructuring of how the tort of negligence in terms of statutory duty and so forth is conceived. And this has been spotted quite recently in the case of Husson. Husson last year, early 2020, was someone who was stopped from working for a very significant period because of a Home Office inability to produce or to issue his biometric residence card. So a very clear situation. It wasn't a case of any dispute over his rights. He was someone who'd won his case, his application had succeeded, and the Home Office just somehow didn't manage to give him a residence card for a year or something, and he sued them for damages. And one thing that the Court of Appeal says in Husson's case is that these recent Supreme Court cases, relatively recent, Mitchell, Michael, and Poole, all cases about ambulances and local authorities, or road or highway authorities. But the idea is that the way that tort was conceived for many years, which was that public interest reasons would normally stop you getting damages, has to be looked at quite carefully again. And obviously for the Home Office, who are constantly exercising public law duties, the scope of these remedies will be of great interest going forward. So Huson is a clue as to the direction of travel in civil cases, a possible widening out of liability. Of course, as one door opens, another one slams in your face, and EU law damages, of course, are departing the stage, still available now and available for up to 2 years of the transitional period ending. Yeah, so basically you should be able to bring EU law damages claims for EU law misfortunes that took place before December 2020, 31st of December 2020. And that's the classic Frankovich case, as it's called. It even gets named Frankovich in the EU Withdrawal Act. And so have a think about that. Especially if you've got people who've been stopped from working for lengthy periods, then it may be that there's an action under EU law, and it's still runnable. In fact, it would not be surprising if there were more Frankovich damages cases initiated now in the 2-year sunset period than there were in the preceding period. Okay, there's a few points on some procedural issues. I think maybe I'll hand back to Pete now to see if Peter's
on the presidential guidance, which is one of the topics we were talking about. If we could go to paragraph 4.39, useful piece there. 4.39, permission decisions, materiality and of interest here, points of public interest. Now, following on from Robinson, which I mentioned earlier, this business whereby the Court of Appeal said it was incumbent on tribunal judges to grant permission in cases where they themselves spotted an important point of principle relating to the Refugee Convention. Presidential guidance from Justice Blake's time as the tribunal's presidency deals with these issues more strongly. Now, the first point is that the standard thing set out there is that grounds of appeal to the upper tribunal should obviously concentrate on the first-tier tribunal decision under challenge. And you don't need to challenge the decision refusing permission by the first tier, but it may be helpful to do so. But then this point is of some relevance here. Well, arguments which are extravagant or contrary to the wording of the binding statute or to a stable and binding precedent should usually be refused permission to appeal. The situation may be different where there is a real case for a precedent to be reconsidered, because a permission refusal would not give rise to an appeal to the Court of Appeal. Remember that a permission refusal by the upper tribunal is an excluded decision, challenged by way of a carte judicial review, but even then, that's only a route to getting permission to the upper tribunal. Once the upper tribunal have refused permission, then that's the end of the matter in terms of it going further in terms of the appellate structure. So the point being made by the tribunal presidents themselves is that there may be cases of public importance for further consideration. And so a permission refusal in those cases wouldn't be appropriate. And also the upper tribunal can now certify a point of public importance in order for the Supreme Court to consider whether a leapfrog appeal was appropriate, in order to avoid the problem of the fact that the Court of Appeal may have set the precedent in issue, and under the Young and Bristol aeroplane principles, the Court of Appeal is bound by its own precedents. But now you have this provision, which we also deal with obviously in the book later on in chapter 4, but we won't be talking about so much today, of onwards appeals from the upper tribunal, which include these leapfrogs to the Supreme Court. So what the tribunal's own guidance goes on to say, though errors of law must normally be material to warrant a grant of permission, this is not always required. While the existence of reasonable prospects of success is a relevant criterion to apply for grant of permission, it is not a precondition for its grant. Though such cases will be rare, the overriding objective to ensure cases dealt with justly and fairly counts against encouraging an appellant whose appeal is ultimately bound to fail, that is bound to fail at the tribunal stage. Nevertheless, the UT may wish to use the opportunity of the application to review the existing jurisprudence on the topic, to address frequently arising problems, or give guidance in a reported case on a novel or important issue. Where there is no reasonable prospect that the error of law related to the grounds could have made a difference, then obviously permission should normally be refused, even if it's on public importance grounds. But that's always worth bearing in mind for certain types of cases where the argument one's seeking to make is caught by Court of Appeal precedents, in order to try and get that reviewed with good, strong arguments, obviously. And as I say, one can see the presidential guidance by looking at this referenced in the footnotes all the way through, including, for example, at paragraph 4.39. So one brief topic we're going to look at is this business of disproving or proving service. Now, this goes back in part to Chapter 3, and I'll be quite brief on this. Chapter 3.26, the service of notice of decisions of the Secretary of State. And there you have the business of the notice regulations which deal with appealable decisions. You also have the leave to enter order, which deals with service and deemed service of unappealed decisions, which I think Mark will talk about briefly in the context of ALAM in a bit. But just briefly, a couple of points here that are worth bearing in mind. And one is this business of modern means and the service of decisions, which could be appealable decisions by way of email. And you have the decision of Lord Justice Hickenbotham in the case of Moomin, where he makes the point, this is the bottom of 326 with reference to footnote 7. Service will not be ineffectual simply because the intended recipient failed to monitor their junk email folder. Now, that really is quite an issue, because one's seen that in a number of cases where the complaint made by the claimant in JR or the appellant in these appeals is that they say they never received the decision, or the solicitors never received the decision. And what Hickenbotham is saying there quite clearly is that it's not good enough simply to say, oh, it went into my junk email. It's your obligation to check your junk email. So a point worth bearing in mind on that. There's another point at 3.100, which makes the point that where a representative is on record, there is no duty on the Home Office to investigate an appellant's address where there is no cause for suspicion about it, and where the matter of changes of addresses to a particular representative is available. So that's always worth bearing in mind as well. Now, as I said, just to finish off on some of these topics, there is reference at 330 to the service of decisions which are not appealable, but which can be subject to judicial review. And there's a whole series of amendments to the leave to enter and remain order 2000, reference to 330, 8ZA to ZC in that wonderful marking way, which deal with deemed service. And a relatively recent case of ALAM references that, when maybe Mark's got a couple of words to say about ALAM, or maybe not.
Yeah, sure. So what we've, there's been a whole flurry of cases challenging Home Office decision making based on allegations of non-receipt of important material. And so what we've seen in the recent case law, including ALAM, is a sort of tendency for the courts have started to look into this with more care, perhaps because they see so many of these challenges. And essentially, I think ALAM and the other decisions seem to require that the person asserting they haven't received something needs to put a really strong evidence-backed case on that. So they need to explain, that there's someone who's always notified the Home Office of a change of address. They need to explain that there's someone who's doesn't change address that often. And if they have a shared letterbox, or they have some kind of system in place for allocating out the post, as opposed to just letting it pile up in the corner. And essentially, that's what I extract really from a series of cases of which ALAM is roughly at the pinnacle. Before we have a look at the questions, I think questions are starting to come through now, which is highly encouraging. But before we do, I think we're going to have time in the circumstances. I wanted to show you a particular paragraph in the JR chapter, of which I was particularly proud. So in one of my paragraphs, what I've done is list the main kinds of judicial review challenge.
Yes.
And here we are, grounds for judicial review, 6145. So it's the longest paragraph in a law book in recent times, and you can see how it goes. Basically, what we've done here is go through all the main case law and separate it out into every kind of challenge, ranging from, there you see it, you see illegality challenges, breach of statutory duties and so forth. You see all the public law errors, because the Iran case tells us that those are JR points as much as appeal points. I mean factual public law errors, and there are other prosaic world that we inhabit, quite often our challenges would be built on those kinds of issues. Irrationality. Pete was talking about the changing scope of irrationality, and it's interesting that judges, depending on mood and inclination and the case they're dealing with and the result they want to achieve, take a different approach to rationality in different cases. It does seem that the judiciary, the Court of Appeal, are going towards quite a close analysis of asylum cases, whereas in the PBS cases, they're just not interested, are they? The attitude in PBS is, well, if the rules say something's required, then it's required, and we're not going to second guess the Home Office in interpreting those rules. Policies, obviously a huge mass of Home Office policies available to us, constantly changing and being updated, and but the Home Office always have to bear in mind departing from a particular policy. There's a policy, leave outside the rules, in fact, which kind of structures that process. But even the leave outside the rules policy can only be the starting point on exercising discretion outside the rules. No mechanistic and inflexible exercise of discretion under policies. The more intrusive the exercise of state power, witness, for example, COVID regulations, the greater the justification is for specificity. And in fact, we saw recently, did we not? We saw with the Napier Barracks JR, one reason why, in fact, the main reason I think why the detention was found unlawful was because there was a lack of cogency to the explanation of quite what the legal governing regime was. Then we see using a mandatory rather than a discretionary refusal reason. And all that kind of stuff can be very important these days, of course, because with many people precluded from the right of appeal because of the admin review procedure in lieu of a right of appeal, admin review with JR to follow, knowing the precise ambit of discretion in particular rules can be really important. And it all changed recently. Part 9 of the immigration rules has had a complete facelift. And regular old friends that we thought we knew, like a Rule 3225, was a discretion to refuse on good character grounds. Now it's an obligation to refuse. So the whole architecture has varied, albeit under the rubric of simplification of the rules. Legitimate expectations. If the Home Office tell you that you can stay forever, well, then perhaps you can, but you better make sure you take a good attendance note of that conversation. And a few people have fallen foul of, the Upper Tribunal because they've usually, ironically, you might say, because they relied on things told to them by the Home Office advice line. But the Upper Tribunal's line on that seems to be that it's, I think they're suspicious that people don't tell the advice line all the facts before extracting the answer that most suits them. Failures to consult. Substantive unfairness. This is a favourite theme, isn't it, of the Court of Appeal in recent years, substantive unfairness. Supreme Court told us in Gallagher that there's no such thing as substantive unfairness, and that's part of the thinking which has led to the retreat from Rashid and so forth, in that actually, if you're complaining about something being unfair in terms other than you didn't know it was coming, you're probably simply pursuing a rationality challenge. The responsibility of the Home Office is another one, in that bullet point. The Home Office, if the Home Office are responsible for something, then they're much more likely to. There's much more likely to be a public law duty on the Home Office to act fairly. See EK Ivory Coast and that line of authority. Very important in the PBS cases. If the Home Office takes away a sponsor's license, then that's the Home Office's doing, and they should. They should give you a chance to improve your position. That's all got rather complicated following Pathan in the Supreme Court. Pathan, of course, now tells us that the Home Office don't have to give you leave, but it doesn't suggest that the earlier Upper Tribunal cases, which encouraged the grant of 60-day leaves to unlucky students, it expressly says that they weren't wrongly decided. So, as always in immigration, we have quite a rich tapestry to follow around. Procedural unfairness, that's a very popular JR point, the best JR point. Did the Home Office, should the Home Office have interviewed you? Did the Home Office interview you but not actually ask you the questions they refuse you on? You look at these PBS refusals of innovator cases or investor cases sometimes. or sole representatives. Sole representatives currently very much in a firing line at the Home Office. Yeah, a lot of these business immigration cases only procedural safeguards an interview, and at an interview, remarkable things happen to you. You're asked a series of questions which are nowhere near the ultimate refusal ground. Age assessment and appropriate adults. I'll tell you one thing. Yeah, here's something worth signing in for this alone. A little bird tells me that the MOJ are thinking about restructuring immigration remedies so that age assessment and fresh claims may leave the field of JR and get a right of appeal. We'll see if that actually happens, but that will obviously be something which is quite significant for some of our work. Inquiries, failing to make reasonable inquiries. There's a favourite one. Yeah, we saw that again recently in the Napier Barracks case. The Home Office had a policy saying that Napier Barracks wasn't ideal for the vulnerable, but they didn't actually have a process in place that could detect the vulnerable. So, classic Tameside failure. Judge McCloskey, he was very keen on the idea that if there was a choice of decision-making mechanism, the decision-maker had to decide distinctly what to do. Should they curtail or not? Should they do something giving you a right of appeal or not? Very keen on that doctrine. Consistency, it said actually, although when Pete and I started doing this in the 90s, we were told that consistency was not a tenet of administrative law, though since then, more recently, the Supreme Court have said it is. Consistency is one of the building blocks of democracy and should permeate any democratic constitution. Departing from judicial findings, that's a favourite, isn't it? It came up again in Al Siri in the Court of Appeal early in 2021. If the Home Office, as party to litigants in adversarial proceedings, are stuck with the result of those adversarial proceedings unless they have, fresh evidence of new circumstances. I did a JR last week that ended up being conceded in a rather messy fashion at the last minute, but there was someone who'd won a case. He'd won 2 appeals based on being a Kosovan from the old Yugoslavia, and the Home Office had lost those 2 appeals based on alleging that he wasn't. But and his argument, we thought it was a good argument, was that the Home Office, who'd made some new recent inquiries, we said they were stopped from relying on that by Ladden Marshall principles. They'd had their chance, they'd lost an appeal, couldn't go back on that now. Well, unfortunately, the Home Office did produce some really very good evidence at the last minute, and so we will certainly wait and see that case in the law reports. So I hope we don't. And again, on we go. All the case law on delay, you see, the cases on unlawful detention, succinctly summarised. Obviously, there are other texts that deal with that. And yeah, there you are. That was a kind of whistle-stop tour. Let's see how many footnotes there are in that paragraph. Well, more than 100 footnotes. Yeah, more than 100 footnotes. Okay.
Just on that point, I wanted to say that it's always worth, when making applications which are covered by policies, to try and make it as crystal clear as you can in the application itself that you're seeking a departure from the policy. And that's certainly true with respect to all sorts of immigration stuff in terms of Section 3 of the Immigration Act and so forth. In other words, an application that makes it clear that you're seeking something, which is then refused, is always easier to challenge than an application which doesn't make that point, and then in the judicial review grounds wants something that didn't appear apparent in the application itself. Now, Mark, shall we look at some of the questions?
Yeah, let's.
So we have in chat an interesting one here. So would Appendix SN, now Appendix SN is about the service of notices, okay, be applicable to a request for payment of IHS within 10 days, where the request was made by email? I'm not sure that links in. What do you think, Mark, with Appendix SN?
Yep. Okay. So Appendix SN, we'll want to look at it, it tells us quite clearly what it governs, doesn't it? It governs the service of admin review decisions.
Or decisions that can be admin reviewed, yes.
Yeah.
Admin review decisions.
Yeah. Okay. So it deals with So more broadly than admin review, though, it deals with notices of invalidity. and notices of voidness. Okay. I wonder if Appendix SN is necessarily the right place to look, because isn't it, some of this stuff on validity is also dealt with in Rule 34, isn't it? Now, Rule 34 in recent years has been expanded somewhat, and many forms of invalidity now have to be given. One has to be given notice of before the Home Office should implement a decision. 34B, where an application for permission to stay doesn't meet the requirement of paragraph 34(1) to 9, Secretary of State may notify the applicant and give them one opportunity to correct the error. Now, so one would have to work out, yeah, which may be beyond me with how many screens I can look at the same time, whether or not immigration health surcharge was one of those. But even if it isn't, either it is, in which case that's the answer, right? Or it isn't, in which case, I mean, you might argue that given that many of, given that the Home Office recognise that many of their ways of finding your application invalid require more procedural fairness than there was 3 or 4 years ago, you could certainly argue on a JR. I'd have thought that the common law has to supplement the rules. Remember, Doody in the House of Lords told us that all rules and regulations and policies are the starting point, not the end point of fairness. So that's my effort on that.
Now, let's have a look at the other questions. So we have another question. I'm not familiar with this, but the Home Office policy of discontinuing BRPs altogether after the 31st of December 24 going to be challengeable? Well, that's a rather future question. EU nationals have been arguing importance of physical proof of status for some time. Non-EU nationals have actually been disproportionately affected and discriminated against by lazy employers and landlords by having a BRP to prove status. Well, so the answer to that is before one gets to December 24, obviously that would be a lobbying issue. In terms of whether it be challenging on JR, I'm sure it will be challengeable on JR. Whether you'll succeed in a challenge on JR will depend to an extent on the reasons given, subject to all the lobbying that goes on between now and the 31st of December 24.
And as Pete perspicaciously highlights there, this point, I'm not being entirely facetious on this, is I mean, the point is premature. Indeed, that's been shown as such, because I think about 3 or 4 weeks ago, the admin court heard a challenge to non-physical identity, digital identity regime, I think they call it, didn't they? And they chucked it out. They chucked it out expressly for being premature. But it was interesting. It was interesting that the really good statistics from the NGO who brought that challenge, that the amount of people, there's something like, there's a lot of people caught by this, and a lot of people are blind. When amongst a cohort, there's a lot of people, a smaller lot of people will be blind. Another lot, 1 in 6 people can't use the internet. More in the Garden Court immigration team, I can tell you. So it's certainly the case that you can, you'll see that. You'll see if you look that up. But that challenge was brought too early. But clearly, the Home Office must know. What do they call it? The judge over your shoulder, as the Home Office training calls it. The judge over their shoulder is going to be on their case if they don't improve things soon.
Okay, and we have somebody's raised their hand. Sabella Siuela has raised his hand to speak his question. Now, what's the text for that? Let's see. Sabella?
Oh, yeah, maybe I think maybe we might have the power to.
I don't.
To unmute Sabella. Now, if David's watching at this moment, David could really step in actually, because it transpires that I'm not entirely sure how to hit this. I've got a mute button, but it's not working for me.
I've unmuted Sabello, so Sabello, you can go ahead and speak. He's having a technical issue. So Sabello, perhaps you could post your question in the Q&A window if that's possible, or email us after the webinar.
Now, we also have from Milmany, when the Home Office declares invalidity, 10-day warning is required under rules and guidance. It says may give 10-day notice, but in guidance it says Secretary of State, the Home Department must. That is, must give notice. Yes.
Yeah, but the guidance is better, isn't it? The guidance is better than the rules, then, isn't it? You know, so I mean, it's telling that, isn't it? So I mean, remember the Home Office. The deal with the guidance is if the Home Office is if the guidance is more generous than the rules, it's difficult for the Home Office to depart from it.
Yeah, exactly.
If it's more restrictive, then it's illegal, isn't it? You know,
the Home Office are guiding themselves. So in other words, what the rule may say is that the Home Office may or may not do something, but what the Home Office then interpret that is for their own purposes to say they must do it to avoid proceedings later on down the route.
So is that actually? So is that that might be all the questions that have been.
Now, I was looking for that code that we had, Mark. Somebody's asking about the. I think I've got it, which I think is that it's. I'm going to try and put this into the chat. It's BPGCCIA20, which I shall try and put in. Type a message here.
I'll read it out again because I found it too. So that is all capitals: BPGCCIA20.
Has everyone got that? I was trying to put it in writing, but I'm struggling.
Oh yes, Emmanuel has got a question.
Okay.
But that might have been an accident.
So, we've got those. We've done those ones. Yes, that's the questions. Where my hands up.
Whether or not Peter worked, I've now put the code in the chat. I think that's yes, that's worked from me, I think. So, well, we may be looking at an early finish here. Yeah, actually, last time we allowed 15 minutes for questions and ended up overrunning by 10 minutes. This time we've allowed 30 minutes for questions, but you know, no one ever complained about an early finish, did they? Certainly not when it's free Zoom.
We do have another one. I think the short-dated BRP issue could become a new Windrush. I believe ILPA is in discussions with the Home Office, who are saying they will tell people what to do in June 24, which, you know, is obviously some way off. I'm not optimistic that all my former child refugees are going to be on top of this. No, well, I see that. Is the case Huson that the admin court said was premature issue?
Huson is the damages case that I was talking about civil damages generally. I'm going to find, I'll find the case. 1 second.
Yes, there seems to be this modern tendency to want to get away from any form in documentary, everything to be sort of done electronically.
Oh yeah, here it is. The case is, unsurprisingly, yeah, the case is called the 3 Million Limited. They've obviously had the sense to incorporate themselves to avoid forking out their too much costs. It notes the potential accessibility issues given the broad range of people applying under the scheme. 13.5% of the over 65s, a third of the Roma community, and a third of the disabled can't use the internet. However, it was too early to say that digital-only policy was unlawful for potential discrimination. As I say, essentially that's because the judge seemed to be saying that the Home Office were claiming that they hadn't finished the consultation, and he said it was therefore premature to stand up for the Roma, disabled, and over 65s.
Yes, obviously ILPA is a very good forum, is a good forum for pursuing this issue at this stage in terms of trying to get the Home Office to not change it. Okay. Now we have another question. brought your book digital form. Are you going to be issuing updates electronically from time to time? No.
No, sadly not. Sadly not. Who knows? That day may come, but we have to rely on occasional sessions like this.
Yes, I mean that I remember I used to do work for the Jackson's Immigration Law and Practice, and we used to do a sort of paper version of updates regularly, and it had become rather impossible to manage because of time limit. People not keeping up to time and all the rest of it. But no doubt there'll be another edition in due course.
And people should bear in mind that once they've spent that part of their book budget, which goes on Symes and Jorro, the Garden Court new McDonald's is out, and that should certainly be the second thing that you buy. And it's obviously totally good, totally up to date, and all the rest of it. It'll be up to date for minutes.
Well, yeah, because obviously we've now got the the current bill going through, which amongst other things seeks to put everything into statutory form. It's quite bizarre actually reading through it. Definitions of persecution and stuff from the qualification directive and so on, a procedure directive going into statutory form for the first time. Quite novel.
I guess that's because of EU retained law thinking, isn't it? They must be thinking that it's an uncomfortable situation that because EU retained law trumps pre-existing domestic law. Not only the refugee protection regs, but even the immigration rules arguably trump statute. That's not new. So there's a massive constitutional crisis on the cards there, and I think we're going to see quite a lot of stuff re-articulated for that reason.
Yeah, so a lot of it is a relatively neutral phrasing, but nonetheless, in terms of the way in which they're trying to actually make it in statutory form, it's quite an odd idea. It's not entirely necessarily beneficial to the Home Office side.
Okay, then. So one feels that with nothing. I'm checking. I think nothing new has come up for a few minutes now in the Q&A. Nothing new in the chat has come up in a few minutes. So I feel we've kind of run out of steam for this one.
Yes.
So look, great to see everyone. Yeah, not that we really see your names, but thanks so much for logging in. As we say, this was once again record breaking in terms of original sign-ups, and I hope it's been useful. I hope what we said to you is useful. As I say, then you can ask anything you want. Don't ask where the PowerPoint is, because obviously having written a book, Pete, our ability to.
Yeah, we won't read by the book. Somebody does make the point: is the discount code applicable to the electronic copy of the book? I don't know, but I don't see why it wouldn't be. It's certainly worth putting it in. I mean, obviously, you understand that's all Bloomsbury. Bloomsbury are the publishers. Okay, so should we call it a day? Now, we've got another one of these coming up in a few weeks. When is that now? That's just in June, isn't it? Wednesday, the 28th of July, and we're going to be talking about remote hearings, which obviously is quite a topical issue. I've noticed from my own diary that remote hearings are very much carrying on for the time being, for better and or for worse.
No, maybe only for the time being. So, I did a UT hearing this afternoon, and the UT judge said to me, "Oh, we're going to be announcing today that everything is the presumption is going to go back to real-time hearings as of next Monday." So we'll see. Obviously, but one is we hear blandishments from the tribunals before, but that's I think the idea is that remote, the great day of remoteness may be passing. So I think remoteness is going to stay popular for anything like CMRs, PHRs, and all the rest of it.
Yes, well, we shall see it. So maybe we'll see some of you again on the 28th.
Good to see you all. We'll log off. Thanks very much.
Bye-bye. Thank you, everyone. Bye-bye.